Savaresi. Hello, everyone. Sorry for the double start. I'm Annalisa Savaresi, and I'm delighted to welcome you to this webinar series at the Center for Climate Change, Energy and Environmental Law seminar series at the University of Eastern Finland. I will be saying a couple of words about the center and myself in a minute, whilst the participants keep joining from the waiting room. The most important thing I have to tell you to start with is that this webinar is being recorded, so we have to be on best behavior. Posterity will see us, and therefore I ask you to be disciplined in your use of video and audio. There will be a chance to ask questions to our excellent speaker today, and I will indicate briefly how you can interact with us in a minute. But first, let me start with a couple of words about myself. I am Annalisa Savaresi. I'm Associate Professor of International Environmental Law at the Center since May last year. And I'm very happy to be part of this large team at the Center for Climate Change, Energy and Environmental Law. We have this webinar series. We started last year. This is led by Kaisa Huta, my colleague who is here with me today. Hi, Kaisa, and thank you very much for your help in organizing this webinar series. Now, the reason we do these webinars is to showcase research that is being done at the center in collaboration with the various partners that we work with. As I will say in a minute, we are in the middle of nowhere here at UEF. And by this, we mean that, of course, we are in a remote location in northeastern Finland, but we are also very much plugged into various research networks. The center is one of the largest in Europe and indeed in the world, focusing on environmental, energy, and climate change law. We are over 40 scholars working together at various levels of expertise and experience. So the webinar series is an opportunity for us to showcase the work we do and our expertise, and at the same time to enable our scholars to learn about each other's work, and of course for others to connect with us. When we organized this semester series, we thought it could be a good idea to showcase some of the work that I did in collaboration with my colleagues, Maria Grazia Labrese from the University of Sant'Anna in Pisa and Joan Scott at the European University Institute. A couple of years ago, we organized a workshop in Pisa where we wanted to find out more about the use of human rights law and remedies in climate change litigation. The plan was to host this in 2020. Of course, this didn't happen due to the pandemic, so we postponed to 2021. And the result of that workshop is the special issue of the Journal of Human Rights and the Environment that is being published and later this month and will be discussed in this webinar series. So it's a very specific angle we are taking to this topic of climate change litigation, but we are very lucky to have with us contributors that have broad expertise on climate change litigation, and therefore will not only talk about rights-based litigation, but will also cover some basics for the benefit of audience. This is the first episode of the series, and I'm very happy to have my co-author and friend, Joana Setzer, here with us today. Joana will in a minute talk about one of the papers that is included in the special issue. It's a paper we wrote together, and she will tell you more, but basically what the paper does is to draw a global map of trends in human rights-based climate litigation, including providing some important definitions and concepts about this specific strand of climate litigation. The next two webinars will be in next week and the week after next, always on Wednesdays at 2 o'clock Central European time. We'll have colleagues from Urgenda Foundation. They don't need any really introduction for people that are familiar with climate litigation. They were involved in the landmark case before the Dutch courts. And the third webinar will be given by Margareta Veverinkesing from Leiden University, who also doesn't need any introduction, and we'll be talking about the paper on youth-led climate litigation that she wrote for the special issue. There were many other contributors, and we had to make tough choices when we had to select speakers for this webinar series. So if they are in the audience, they know that we had to make a short series. We couldn't present all the papers, but the Global Network on Human Rights and Environment is hosting a blog series where all contributions will be showcased. And if you're interested, you can Google me, send me an email, and I will be able to share with you the information of that series as well. Now, without further ado, I would like to give the floor to Joana. Joana joins us from the Grantham Research Institute at the London School for Economics and Political Sciences. She is a veritable climate change litigation guru, has been for many years curating their database, and she knows everything you want to know about climate change litigation. Joana will be talking about the paper first, and then there will be a reaction from me, and from then I will open the floor, and you will hopefully engage in a discussion with her on the ideas she will illustrate. So without more blabber from me, Joana, please, the floor is yours.
Thank you so much, Annalisa, for the introduction, and thank you, Kaiser, for inviting me to present today and organizing this. I'm delighted to be here with you today, presenting this paper that Annalisa and I have been wrote together, and it took many reiterations until finally we got to this happy moment of seeing it out. And this is actually the first time that I'm presenting the full paper. We've been presenting it in short versions. So the first time that we have a whole webinar just for this paper. And I really think that it merits that time, because we did pack a lot into the paper. And I feel it's helpful to go through it, and you know, then hopefully you can, after this webinar, if you haven't read, go and read, and it makes even more sense. So I would like to begin sharing my screen because I have some slides here for you. So let's see if this works well. Can you see my slides? Yes, good. Excellent. So I'm aware that many of the people attending this webinar might not be 100% familiar with climate litigation and what this is about. So we thought that it would be helpful not to jump straight into the paper, but to give some overview before. So this is what I'm planning to do in this presentation, to start with a very, very brief overview of climate litigation, and then where rights-based climate litigation sits within, and spend most of the time of the presentation looking into this paper. And I will break down into looking at the gap that we identified and addressed, the aims and what we found, the methods, and what we saw in terms of future research. As Annalisa mentioned, the paper is now out in the Journal of Human Rights and the Environment. We're trying to sort the open access. So if you click now and you don't have the full access because your university is not signing up to this journal, then bear with us, because it should be open access soon. And we also decided to write these blog pieces that are summaries of the paper. So there are 2 already blog pieces looking into the paper, and these are the ones that I have in that slide. So this all happened this week, so all very fresh, and you're getting a very first look into this in the first presentation, as I mentioned. Good. So I begin with, as I said, trying to contextualize where rights-based litigation enters in climate litigation. For climate litigation, what we do, and this is something that has to do with the analysis and also with the data collection, is that we define it quite broadly, and then sometimes we try to go a bit narrow, just to facilitate the data collection. And the way we define is that we define as the lawsuits that are brought before administrative, judicial, and other investigatory body in domestic and international courts and organizations that raise issues of law or fact regarding the science of climate change and climate change mitigation and adaptation efforts. So this definition goes back to one of the first papers that was published, and is still very much the definition that is used. However, as I mentioned, when we are collecting the cases, and I will talk to you about more in the methodology of the paper as well, but we tend to apply it in a more narrow way, in that we really want to see a discussion on climate change in the case. But these cases, this body of climate litigation, can be brought on several grounds. So for example, you can have cases that are grounded on planning and administrative law, commercial law, civil and tort, criminal, consumer protection law. So many, I would say almost all areas of law could have a case of climate litigation. What we do in our paper is that we look into climate litigation that is grounded on one particular area of law, which is human rights. So this is to remind you that we are looking at a very small, I would say, subset of cases, but one that has become increasingly important and also influencing others, which is a whole different story about impact of climate litigation, and that we can discuss later. So when we look into this subset of human rights-based climate litigation, we're looking at similarly the lawsuits that are raising questions of law or fact regarding climate change, but that rely in whole or in part on human rights. So this is where we narrow down and zoom in and try to understand, okay, what is it about just this subset of cases? And then this is where I want to start really looking into the paper. And first, why we felt that there was a need for such paper. And the main reason is that if you follow climate litigation, you will see that increasingly we're seeing human rights cases, and you would have known this paper published by Jackie Peel and Harry Ozovsky in 2018, where they identified and kind of predicted as well this so-called rights turn in climate litigation. So, okay, in 2018, they said that we would see this rights turn. The next question is, have we seen that right turn, and what is about this right turn? What can we say about it? And this is where our story begins. So we start collecting all the cases that would classify as rights-based, and I'll talk to you about that methodology. And we identify a considerable increase and quite a high number of cases. So for example, in 2018, they said that there was this high rights turn. After 2018, we have 2/3 of the rights-based litigation being filed. So really that's the prediction seemed to have to materialize. And then we have this body of cases that we say, okay, this is rights-based litigation. So what can we say and what's missing? So what's missing is that the analysis until recently has been very much looking into specific cases, one or two or a few cases, a handful of cases. And we hadn't seen yet this big understanding of a big picture. So what is it if we try to understand what all these cases are about? And this is the first gap that we identify, kind of not having that big picture. Then the next big gap was that we realized that when cases are discussed, the cases being discussed are the cases that are aligned with climate objectives. But there's a whole other part of this, which are cases that are not aligned with climate objectives, which we know very, very little about. So this was the second gap. So with this beginning, we went into looking at the full picture. And we started this paper with a different title and a different terminology that we were using. We said that we wanted to fully appreciate the whole of human rights law and remedies in climate action. We wanted to understand the whole of the moon. So we knew that there were some cases that were better known. So those we were calling the near side of the moon, and there were all those cases that we knew very little, the far side of the moon, and we wanted to understand the whole picture. Unfortunately, this metaphor didn't go through very well with the reviewers, so we had to drop it out, and the paper ended up not having that, but we still can use it in our presentations, and I'm using here. So back to the aims and what are our key findings. I'm already anticipating here, so you have a bit of a spoiler, but the first thing we did was to identify all the known rights-based climate cases. And we did that with the help of a really wonderful research assistant, Gwen, who was helping us to get all the cases from the databases and categorize those cases, then understand the characteristics. And this is why we were able to come up with a typology that we hope is useful. So that's the first contribution. We provide the first systemic analysis of rights-based litigation that aligns with climate objectives. So it's the mapping of the near side of the moon. Second, we start the exploration of the other side of the moon, the further and less known side of the moon. So for that, we compiled some cases. We looked and tried to understand the variety of cases that we could find that were not in the databases. And we tried to understand what they were about and ended up coming up with this definition of just transition litigation, which I will get in more detail towards the end. So the second contribution is that we didn't resolve the gap, but we identified the gap concerning rights-based litigation that does not align with climate objectives. So the so-called just transition litigation. And now let me tell you how we did and what we found in more detail. So first, the methodology, how we compiled that. So you might know already that there are two main databases of climate change litigation. These are maintained by the Sabin Center at Columbia University in collaboration with us at the Grantham Research Institute at the LSE. So we work together and we identify and write summaries and upload cases from all around the world. The Sabin colleagues have the US litigation, which we don't at the Grantham, and we at the Grantham have the non-US and all the laws and policies which Sabin won't have in theirs. So these are our sources, these databases that we sit on and that we could kind of easily manage. So with that, we were able to get all the US and non-US human rights cases in principle, until we started noticing that we were missing that's the far side, and unfortunately there are no databases that would have that type of case where climate is not central to the case, so therefore not included in our databases, but are relevant to climate and are human rights cases. So we looked mostly into this database that the Business and Human Rights Resource Center has, which is also not comprehensive, but gave us an idea. And then we have this beautiful spreadsheet with which Gwen helps us putting together, where we started doing really the classification of all the different categories. And this is the second part of the methodology, how we go about analyzing, right? What categories are we looking? So for the first part of the paper, we classify all the 112 cases. I hadn't said this number, but we identified 112 cases based on categories and trends in climate litigation. So these are quite well established. You go back to the paper I mentioned, the Markle and Rule paper in 2012, and it's something that we do annually for the global trends in climate litigation reports that we publish, the Grantham publishes. So this is where we get those categories for overall climate litigation of who's filing against who, where, when, and what are the outcomes of the case. Very well. So this is what we had for the overall litigation, climate litigation. For human rights, we then use well-established categorizations of human rights and environmental litigation, which usually will divide cases based on the set of obligations. So for example, if the case is dealing with procedural or substantive obligations. And we then backed up that into also well-established literature. So this tells you how we went about collecting the cases and analyzing the cases for that first part of the paper, which is the known cases. And what do we find? So we find, not surprisingly, that the number of cases is increasing. So if you look here at these graphs, what we did is we compare the subset of human rights litigation with the full set of climate cases. And that was also interesting because we could see what is special, what is different and distinct this subset from the overall climate litigation, which is growing into something quite big and varied and diverse, as I said. So in terms of numbers, the numbers are growing. In terms of the chronology, or when this type of litigation emerges and when it's growing, we noticed that human rights climate litigation is a newer phenomenon. So if you see the general climate change, yes, it has grown more significantly after 2015, but it started back then in actually 1986, but it's growing quite solidly since 2005, whereas the human rights-based cases are really picking up, definitely after 2015, but especially after 2018. This analysis is, again, US and non-US, and up to the 31st of May 2021. And this is why the last bar is slightly shorter, because it goes, it's just a few first months of 2021. Good. So now if we look at the geography and where these cases are being filed, what happens was also quite interesting to see that there is a distinction between the human rights cases. Whereas in the general climate litigation, the vast majority of cases is filed in the US. So you see this big bar at the bottom, vast majority in the US, with kind of some cases in the Asia Pacific, that's mostly Australia and Europe. If you zoom into the human rights and climate litigation, you see that it's much more balanced, that the US doesn't respond for the vast majority. Actually, Europe has the majority of cases, and that you have proportionally many more international cases, many more cases in Latin America, and even Africa, which is very insignificant in the overall litigation, becomes less insignificant, I would say significant. Also, if you then look at the content of the cases. The next analysis we do is looking at who's filing these cases and against who. And again, we identify some differences between general litigation and human rights and climate litigation. So the human rights and climate litigation has been typically filed by individuals and groups and against states and public authorities, which is not surprising, right? That would be happening, especially as corporations usually don't have human rights. However, this is changing, and we see a small but also quite important and high-profile cases being brought by corporations. So we identified 16 human rights and climate litigation cases filed against corporations. And the numbers with the general litigation are slightly different. Historically, also, we've seen NGOs, but many cases filed by corporate actors. And these are the cases that are challenging, for example, regulations or the withdrawal of licenses and permits. So again, another layer where you can distinguish general litigation from human rights. The last analysis of global trends type we do is looking at the outcomes. And this is a bit of a tricky one because, well, first of all, most of the cases are still ongoing. So the sample we have is not a large sample. Secondly, and most importantly, is that we do a very narrow analysis of outcomes where we look at the basis in which the case was filed and what the decision was about, and therefore the outcome, is it aligned or not aligned with climate objectives? So we all know that particularly with strategic or this high-profile litigation, often the main reason to file a case is not that you are sure you're going to win, but that you want to convey a message, you want to raise awareness, you want to push towards a new legal theory or application of certain law. So there is that strong strategic component, which an analysis so narrow like this of outcomes wouldn't cover. But still, it's interesting to see, for example, I would ask, well, so are these, by filing a rights-based case, do you have a better chance to win than if you're filing, other type of case based on commercial law, for example? So you could try to do analysis such as these ones. And this is what we did. And we found here that in the general litigation, so far, most cases have been most successful cases have been aligned with climate objectives. Whereas if you look here at the human rights, you see that 56% have been unsuccessful and 44% successful. So the difference is not massive, but actually so far, and again, we have very few cases that have been decided in the last instance, but so far the majority of cases haven't resulted in outcomes that are aligned with climate objectives, which is kind of, I find also a bit surprising for the moment. That could well change soon. Very good. So then this was the first part of the paper. And we get into the second part of the paper, which is this analysis of the types of human rights that are mostly frequently invoked in the cases. So this is where we have this typology that we're bringing in the paper. In the paper, you will see we only have the typology without the number of cases, but for this presentation and for the blogs, I thought it was useful to already add the numbers and some examples here into this slide. So we begin with the typology for rights-based litigation against states. The other typology is for rights-based litigation against corporates. And in the litigation against states, we have 93 cases, which we divided into the substantive and the procedural. So the majority of the cases have been the substantive type. And these can have both be seeking a positive or a negative obligation. So in terms of a positive obligation, this could be of two types. It could be to adopt legislation, and the classic example there would be the agenda case, or to enforce legislation. So the judge sitting there is Justice Ali Shah, and he was the judge in the Ligari case, which basically told the Pakistan government to enforce existing legislation, which is what's happening today in this really important day in the Supreme Court of Brazil, with the Supreme Court deciding on 7 environmental cases, some of these climate cases that basically deal with issues of enforcement. Very well. So the second type of substantive cases are the ones that are seeking a negative obligation. And here we have one type, which is refraining from harmful activities. The example that we gave is the example of the case filed by Greenpeace against the Norwegian government. And there are many others. As you can see, we have 30 of these cases. From the substantive to the procedural, we identified a smaller amount of procedural cases dealing with procedural obligations. these would be cases dealing with access to justice, participation, and access to information. We were not able to find any case dealing with access to justice against governments, but we did have a few, mostly on access to information and a few on participation. So here we have the example of, which examples did I put? I don't remember anymore, the photos that I decided to pick here. But so we have the, oh dear, I can't remember anymore which ones. This, right. Yes, the Ryanair case, which is in Ireland, filed by Friends of the Irish Environment, which dealt with participation in the process of permitting of the airport in Dublin. And the other one, which is a case filed by Greenpeace Luxembourg against the government, also in Luxembourg, where the applicants are complaining about public authorities having failed to respond to a request for information. So it's an access for information case on how the National Sovereign Pension Fund plans to align with its investments with the objectives of the Paris Agreement. So an access to information case. So this is the typology that we have for the cases against states. I move now to the typology of cases against corporates. And here we have the smaller number of cases, the 16 that I mentioned, and the vast majority being substantive. Of course, these have gained a lot of attention recently, particularly with the decision in the Shell case, which we have there as one of a positive to reduce emissions. Of course, some of these categories overlap, so you would have a case that falls into both, so that's important to mention, but some cases will be mostly in one. So the other type of positive obligation is to support climate policies, and the example here is the carbon majors inquiry in the Philippines, where this is one of the issues raised in terms of companies not fighting against but supporting climate policies. In terms of negative obligations against corporations, the example that I have here, no coal in Japan, is a case filed by a group of families in Kobe in Japan, where they're challenging the operation of 2 units of coal-fired plants in Kobe. This is, so the case is challenging specific activities, could be either or both against states and corporates. Now, on the procedure side, we only found 2 cases here, and both dealing with disclosure, and one also with consultation. So this was also a bit surprising, considering that in normal general environmental law, you would have many of such cases, but so far we were not able to identify so many of such procedural cases. The ones we have actually have been brought before the OECD national focal points. And this is also something interesting to note. As I said, we consider also administrative non-judicial procedures. And the example that I have here is, again, in Japan. It's a complaint filed by an NGO against 3 banks in Japan, where they claim that the banks have failed to disclose information on projects' emissions from that they are funding. So what we hope here is that with this mapping, we will help scholars and other colleagues involved in litigation understanding where the cases are and where their cases might fit and where cases haven't yet been brought, and that this provides a really useful map for anyone studying this topic. So we mapped what was known, and then I want to finish my presentation with the map of what is still yet to be discovered. So as we were going about, as I said, we found that there are so many cases that were also relying on human rights in part or fully in their arguments, that had, to a certain extent, an importance for climate policy making and climate action, but that we didn't have in the database because they were only very peripheral climate cases. And what was striking about these cases is that often they are, you could see them as cases that will go against climate action, but that's not their real objective. So, I wouldn't like to classify these as anti-regulatory or defensive cases as in the climate litigation literature we tend to classify, but they are cases that have that bring the human rights aspect of or how the human rights enjoyment might be affected by communities that are affected by wind farms or a hydroelectric plant or biofuels. And this is where we decided to define these cases as just transition litigation. So we have an initial definition for this set of cases, and we define them as cases that rely in whole or in part on human rights arguments to question the distribution of the benefits and burdens of the transition away from fossil fuels and towards a net zero emissions. So a working definition, which we hope that can be further explored. And this is how I want to finish my presentation. I'm getting close to the half an hour that I wanted to speak and open to Annalisa and to other questions. But we want to finish, we wanted to finish the paper with an invitation for a discovery of a new knowledge frontier, a new research agenda, and one that has to understand climate litigation as a complex issue that reflects the complex nature of the problem. And that's often by trying to find this equilibrium between competing social interests, litigation will be filed from different directions and often will try to protect human rights that would be somehow threatened or affected unjustly by the transition to a net zero. So what we want with this paper is to raise also awareness about this whole area. Hopefully this will mean better data collection of these cases and more research to understand what these cases are about, and not just understanding the phenomena, but also to understand how policies, how legislation can safeguard rights, so both procedural and substantive rights, and protect individuals and groups from unjust decisions of governments and corporations. So I stop here in exactly 30 minutes, I think, which I had planned. And I'm looking forward to hearing more from my colleague Annalisa, with who it has been an absolute pleasure to write this paper, and also to hear from those of you who have been listening to this presentation.
Thank you so much for that, Joanna, and indeed for the kind words. It's been a labor of love. It's fair to say that it's been a complex paper to write, and I guess the audience can understand the massive amount of work that went into this paper. It is a synthesis paper. Possibly we should have done something more long-term before we embarked on such a challenge. We thought, how difficult can it be? We mull through the cases in the database, we see what we discover, and then we discover that we had many more questions than answers. Combining qualitative and quantitative research is difficult, especially when there's nobody else who's written on a topic. As we were finding ourselves, there was a lot of papers that were looking at selected cases, but nobody tried to build a big picture. And the minute we started to go into definitions and try and draw the lines of the scope of our investigation, we found cases like some that are mentioned in the chat, like Ogoniland case in Nigeria. Is it a climate change case or not? It's certainly a human rights case. It deals with oil and gas. It has relevance to climate change, but is it a climate case? And we started the conversation like this, and we ended up having lots of these conversations in the following months. So it was great fun, I would say. And I think that to our advantage, we had a relatively small number of cases. 112 is not small, but definitely smaller if we did the same work today, we'd have many more cases to look at. And I think that you have to be strategic about when you decide to do an exercise like this in terms of feasibility. I have a number of questions I'd like to ask Joana, but there is a lot of questions in the chat already. So before I ask my questions, I think I'll give the audience a chance to raise some points. I have summarized questions, Joana, because I don't expect you to read all of it is in the chat, but we have one question about regional differences in success rates of human rights-based cases, if we can say something about that. Human rights-based cases that also rely on trade law, if any of that exists. And finally, litigation against board members. Again, there is, of course, the recent case against Shell that is brand new, but there is a question that specifically concerns this kind of litigation. And I think I'll leave it to that for now because there's plenty already.
Classic. Excellent. Thank you. Very good questions already. And very good points you also raised about our ambition with this paper, how we we didn't think it was going to be such a complex task, and it was. It makes me think, you know, sometimes I did have that thought. We probably had two papers that we ended up combining, at least two, like 3, 4. But yeah, probably 3 is a fair. Like, one was the mapping of what we know, the other one was like the new research agenda, and so it ends up being a paper with a lot in, but hopefully a useful one. Now, answering to the questions, we haven't done this analysis of success across regions. It wouldn't be difficult, really. I can easily do this, and I don't know who asked the question, sorry, I wasn't following the chat box, but it's something that can be done. I don't want to say something like what my feeling would be about it, but because that's also the good thing about when you start working with data, that often you would say, like, yeah, I'm quite sure that the majority of successful cases have been in Europe and then in Latin America. And then you look at the data, and actually it's not exactly that. And so I will look at the regional differences and get back to you on that question. That's a good point. On litigation against board members, that's such an important type of litigation that for a long time I've been just waiting to see happen. And of course, because from a strategic perspective, it is so powerful to file a case against an individual rather than against a company. And if I work at Shell, and I might be happy that this litigation is being brought, because I think, yeah, it's great that, you know, Shell is being pushed. I work at Shell. I've been trying to get to convince Shell or the government where I look for a long time about how this is important, and they just didn't listen to me. So delighted that someone filed the case and now the company is doing, or the government is doing something about. And that, you know, I'm saying that because I've heard already more than once people in government and people in companies saying that actually they were happy with these lawsuits. Well, that changes very much if you're the one who is responding. No one really likes being involved in litigation. It's terrible, and that fear that the directors and boards would have, it was up there and hadn't materialized so much until, as someone also I think mentioned in the case, this case that was filed a couple of weeks ago by Client Earth against Shell. So that's something that I would imagine will grow, and that it will have quite a significant impact in governance within companies. We had cases against individuals, against states. For example, if you think about the Australian cases, they are filed against the Minister for Environment. So there is that individual component of some of that litigation, but individualizing I would expect, and we can do research on that, or I invite any of you to do research on that, to compare the responses or the impacts of litigation against entities, corporations, organizations versus against individuals. And I would imagine, it's not something I have started looking into, but I would imagine that there are other areas of litigation which already have done this type of research. So there you go, a good research question. And human rights that rely on trade law. I can't remember any. I don't know, Annalisa, how is your encyclopedic memory working? I can't remember any now.
No, neither can I, to be honest. And I do think that WTO law and human rights law in this regard are a bit divorced. But maybe the person who asked the question would like to elaborate a little bit more. I think it was Hannah, if she's still with us. Hannah,
Yeah,
do you want to open your...
On that, we were going to say, if you want to just unmute yourself, go on video and then talk to us. That's very welcome.
Hi, this is Hannah here. So
Hi,
hi. My question was just in relation to whether or not you've seen any cases of this nature under the WTO, or maybe under other trade agreements such as NAFTA or the EU, if there's been any litigation in those spaces.
So we have recently started to map investor states dispute resolution, ISDS, and included, if I'm not mistaken, 13 or 14 cases that are climate cases into our database. Those until recently were not part, and now we've included. We did some initial analysis to understand what they are about. They are not human rights cases though, and I haven't come across yet WTO cases, and it's, I've been already thinking about this, and it's a question that already came. I think it's an area to explore. I don't think we have any example so far, at least kind of climate and human rights cases, and I wouldn't be surprised if that's another of these areas that we'll start seeing more litigation and in the near future. But as far as I know, Hannah, so far I don't have any example to share with you other than the ISDS cases.
Okay, thank you very much. I will look into those.
Let me know if you find anything.
Okay,
You know,
it's actually...
Yeah, please.
I'm doing a PhD level research at King's College London around trade and climate in Africa. So this is something that is, very much of interest to me.
Wonderful. We're just down the road from you, and it's a new area of research, as you all know. A lot of what we do is by talking to colleagues, by someone pointing something to us that we haven't identified. It's an area that is also growing so much that I feel in the beginning it was easier to keep track of what was going on, and now it's good, I guess, but it's we need some insights, and if there's anything missing, please do let me know.
I'll be in touch. Thank you.
Great.
Thank you very much for that, both. There is a number of questions that I've taken notes and summarized. I'll take quickly a couple, Joanna, just to give you a quick break. There was a question by Johan concerning the right to a healthy environment and pro-climate litigation. I have actually been writing a paper on this, and my co-author is not here, Pau de Vilches. I apologize to Pau because the paper is sitting on my desk, but it will be submitted soon, and basically builds on the work I did with Joanna, but really tries to understand the role of the right to a healthy environment in the context of climate change litigation. It's a complex exercise because normally human rights are not invoked on their own. They're invoked with a bundle of other rights. So it's very hard to unpick the effect of one single right, but we are trying to do that. So watch this space. There is a question about just transition and the role of human rights in unpicking the complexities of the just transition. Clearly, the ILO has been talking about this for a while. The notion of just transition in itself is one that is difficult to define. Now, the role of human rights here is undisputed. What I think is really interesting is to drill into the details and understand what this means in practice. Thankfully, we have a new special rapporteur on human rights and climate change that is going to reveal us all what the role of human rights is in this context. And this is a very large task, to be honest with you. But thankfully, there is a lot of practice already in this area from the area of human rights and environment that they can be usefully, used as a premise to develop specific guidelines, because the magnitude of the energy transition is unprecedented in terms of policy revolution on a number of levels of society that will have significant implications for the enjoyment of human rights by large parts of the population. So there is a lot to be learned, and we don't really have the answers, but we definitely think that looking at the litigation concerning these matters is really important going forward. Then I wanted to put a couple of questions to you, Joana, because there is a couple of comments about corporate actors relying on human rights in climate change litigation. I do not know if you know any of that, so you will enlighten us on this point. And also the endless question of definition and how definitions that are being developed in the literature concerning litigation in the global north apply or can be adjusted to litigation that takes place in the global south. And I'll leave you with these two for now.
Thanks. And I just now managed to go through the list of people attending, and great to see that Gwen Wren is here, and she's, as I mentioned, our research assistant for this project, and also Maria Antonia Chigri, who just mentioned that the Sabin Center, through their network of rapporteurs, is going to start including WTO cases. We work together, but I wasn't aware that she was here, so that's great, Maria Antonia. And also Vedanta's question on the companies using human rights to file cases. So that's an interesting one. And we do have an example, I think it's the DG Cement case in Pakistan, where a company is challenging, so it's a cement company that wants to build or expand, I don't remember the details, but then it's not allowed, and says that that would go against their right to develop and something along, like, you can imagine how many of these cases actually could be filed. When I was a lawyer working in a corporate law firm, we used to defend all the environmental cases like that. You know, we would say that the company was protecting the right of the employees, and that the right to property, and so many rights that also needed to be protected against unfair between companies. So that's something that we've seen a lot in environmental law litigation. I wouldn't be surprised that we start seeing in climate litigation. Again, it might be a blind spot that we haven't been collecting those cases, or it might be that the companies haven't understood that that's a strategy that they might be able to use as well. But Vedanta, I see that as a likely development in climate litigation. And then you would think, I think the next question is, would you call those just transition litigation? I would be tempted to say no, because I would imagine that the just transition litigation would be involving, yes, the workers and the communities affected, but not necessarily the companies. So we would, when exploring further this idea of just transition litigation, we'll also have to grapple with how do we then understand the cases that are filed by companies claiming their own rights, and within this just transition. So that opens there will have to be a lot of nuance and a lot of questions and reflection to address this. The question on Global South and North, so that's one that I've been also interested in a number of other papers, and in data collection that does play a big role already, because often cases in the Global South are not filed as climate litigation and knowingly by the litigators, because a combination of factors, because it could be that in that country, climate change is not so high in the agenda that they wouldn't get support from the other citizens and the community that supports that NGO, for example. B, because the judges are not still ready to deal with this type of cases. So there are many reasons why in the Global South, climate relevant cases have not been filed as climate cases, and rather they stick to the more daily pressing problems of air pollution and water contamination, instead of also adding that layer. The same can be said about deforestation cases in Brazil. There are over 9,000 cases dealing with deforestation in the Amazon, environmental law cases, which never mention the word climate. And of course, deforestation and climate are very much connected, especially it's the main source of emissions in Brazil. So there is that aspect, which is definitely important, in that often cases are not framed as climate in the South yet, which is something that we discuss. And when we, Maria Antonia and I, talk to partners in Global South regions in terms of the collection, we tell them, look, for you, these cases could be relevant and you're very welcome to consider them as climate cases. We cannot include 9,000 cases because we just wouldn't have the capacity to update the database after. So I think also there is an important question about regional diversity and how some regions can have a different set of what they understand as their body of climate litigation in their countries. I don't know if there was another question, but I realize that we're getting to the end. So there's so much to talk and so many amazing questions that I saw coming in. So that's excellent. It's Indeed. Really, after all that hard work, Annalisa, it feels good to be able to present and to have so many people that are interested in asking these questions. I guess this is the beginning of a conversation.
Absolutely, Joanna. I couldn't agree more with you. Thank you so much for taking all of those questions so efficiently. There were a couple of points raised by Agni, and I think it was Carlotta, still concerning definitions and the interplay between litigation against states and litigation against corporates. Now, there is some literature on both issues, but what I'd like to say generally is that, at least from a human rights perspective, litigation against states and corporates is quite different, because there are different obligations of these two sets of actors. And in some cases, it's very hard to pinpoint to obligations, formally speaking, for corporate actors. It really depends on domestic law, because we have little common ground. We have UN guiding principles, but not all courts are willing to rely on these guiding principles. So the existence of due diligence legislation makes the life of litigants much easier there. But against states is a completely different game, and this is really quite widespread and common. Carlotta talks about the possibility to widen the definition of climate change litigation. I think this is a dangerous exercise for the reasons that Joanna just mentioned. And in fact, I think everybody that is working on climate litigation is actually looking at doing more of a kind of exercise that Joanna and I just did, and drill into the details of specific areas, because this is what litigators also need. They want more systemic knowledge about various pockets of practice, so that we understand better which cases are successful and why. And this is part of the physiology of the life of an area of the law. When we're talking about litigation, we're talking about litigation in civil law, litigation under administrative law, litigation under tort law. And this is going to happen for climate as well. The issue is the specific role of climate legislation in this kind of litigation. And this we have to find out, because climate legislation is a young creature The countries that had the legislation for longest are the UK and Scotland. And we are talking about legislation that is 14 years old at best. So we have a lot to learn. And this is why it's so interesting to talk about this topic. And Joanna and I, for sure, will continue working on this. And I hope many of you will as well. I thank you so much for engaging with us so vividly. And I hope to see many of you at the next webinar, because we have the Urgenda folks with us. And it's going to be really exciting. So next Wednesday, same time, same place, but please remember to register if you've not done that already. And thank you so much again for being with us. Thanks, Joanna. Thanks, Kaisa. See you next week.